Hi, y'all, and welcome to tonight's live stream. Well, the Commonwealth has finally put the star witness of the case on the stand. Yesterday went pretty well, but how is the witness holding up on cross-examination? Because that is the real test. And is the witness doing as well as the state was hoping? Very, very withering cross-examination coming in from Robert Alessi, one of Karen Reed's lawyers. Yesterday, crash reconstructionist Dr. Judson Welcher walked the jury through the state's theory about how John O'Keefe might have died, about what happened that night. The force needed to break the taillight, the height of the spoiler, the angle of John O'Keefe's arm, talked about all kinds of things specific to what happened. But today, Karen Reed's team, the defense team, had a chance to cross-examine and had a chance to ask all of the questions that we all had yesterday. Was he ignoring the fact that John O'Keefe might have been standing on a curb, for example? Was he assuming the worst without considering all of the possibilities? How can he be so confident, given that the state's own autopsy found that John O'Keefe had no hand fractures, no x-rays, no evidence of where exactly John O'Keefe was standing, not even of where his body finally wound up on the lawn? So they also pushed him really hard on confirmation bias. Was he just blindly adopting a theory that he had already believed, or was he truly using scientific principles to examine the evidence? So what happened today? Did the jury hear from an expert witness with a clear story, or was it someone who could not quite answer the most important questions? That's what we're going to get into tonight. That's what we're going to break down on what happened today. Now, one of the things I want to say right off the bat, and I've talked to y'all about how incredibly important it is, the power that these expert witnesses have. It's more or less new in the terms of the legal profession and in terms of what's happening in the legal cases. But it is all important what these expert witnesses say. And there's a battle on both sides. One brings an expert, the other brings an expert that says just the opposite. It leaves the jury with a lot of questions, a lot of wondering about what the truth is. Well, in this particular case, there was this particular expert is really good. Now, we have heard from some other experts during the course of the trial and from the last trial who really were not good expert witnesses, but a truly great expert witness is one who can handle all kinds of questions, who can deal with a lot over the course of the examination. And that makes for a very difficult time for the attorneys. The attorneys have a very difficult time cross-examining one of these witnesses. The attorney is not on the footing of knowing exactly what their topics are, and the witness is smooth and slick, really good. And that is exactly how the ARCA witnesses were in the last trial and how they will be again in this trial. This witness also is it's like that. You know, one of the most important things you have to do as an attorney when you've got a witness like that is you have to really watch how you come across to the jury. It can be very frustrating for the attorney to know that what's being said is really inaccurate or that they aren't answering your questions. But when you have a witness who appears pleasant, you have to remind yourself, okay, the jury doesn't know this person. The jury doesn't know what I think they're hiding, and I'm going to have to be really careful. So I want to show you an example right off the bat where early in the cross-examination, I think Alessi got fairly frustrated with the witness not answering questions and being very skilled. You are going to see Alessi get smoother and smoother and do better and better throughout the day. But I want to show you an example of what can happen. And what if I were on the team with Alessi, I would have said, yeah, cool it down. They don't know this witness yet. You got to go in slow. So let's go ahead and start with that, and then we're going to watch the day develop.
Aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed, it's just it was pointed out to him that that should be looked at? What's the basis of your understanding that he found new information?
Objection to the question.
I'm going to allow the question, but you have to ask it differently, Mr.
I will, Your
President.
Honor, thank you. What is the basis for the statement you made that Mr. Burgess found new information?
Okay, so you can see where this is really common for lawyers because this is a super difficult cross-examination when you have a really smooth, qualified expert witness on the other side. It's difficult. And you were going to see Alessi struggle with that, particularly at the beginning of the day, and then really start to get his feet under him as he does that. So in this particular case, I did forget to do something at the beginning. First of all, I want to say a special shout out to the first 5 in tonight's chat: Camilla, Juliana, CJ, Loretta Powell, Abby Normal, and Oklahoma Gigi. Glad to have all of you. Glad to have all of you watching tonight. So one of the things that Alessi would love to do, that the defense team would love to do, is to cross-examine Dr. Welcher on Trooper Paul's report. For those of you who followed the case at the first trial, you may remember Trooper Paul. He did the reconstruction for the Commonwealth, and that cross-examination was just utterly disastrous for the Commonwealth. He clearly had not done the thorough examination he should have, and didn't have the background to be able to answer some of the questions. So the Commonwealth has brought in someone who will be a lot more polished, someone with a background that would at least theoretically be able to stand up to what is going to be asked. And there has been a real effort to cross-examine this witness on Trooper Paul's report. It would be great from the defense standpoint if they could put up there if they could cross-examine this witness on what Trooper Paul said, because it went so poorly and because it's not the same thing that this witness says. So far, they haven't been able to do that, but they continue to keep working and trying at it. And you're going to see some of what happened there. Let me add the
Did read Trooper Paul's report.
Of course.
So, you therefore are aware that the Commonwealth has maintained up into your engagement.
I'm going to see a sidebar on this.
Are you aware that over
Okay, so immediately the judge is like, wait, whoops, we're not going to ask him straight up about the difference between Trooper Paul's report and his report. Instead, you're going to have to get that in evidence. Right now, you don't have it, and you're not going to be allowed to ask about that. Now, she also made a fairly pointed comment to him. You'll watch that happen in
the course of the Commonwealth in your investigation into this case, that the theorized time of the alleged contact of the SUV.
So there's 2 words to strike: theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your...
Well done, Mr. Alessi. The court reported copy.
Thank you. I will.
Thank you.
I'll object again to the question that's coming.
Can I
Go
begin
ahead
my
and
question?
ask an appropriate question, Mr. Alessi.
Sure.
She says, ask an appropriate question, Mr. Alessi. She's really being cautious, and she's trying to keep him on the path that's been approved. He would like very much to go into asking about Trooper Paul's report. That would be really important for Karen Reed in terms of it would be something that could really be used to damage this witness and this witness's credibility because of the conflict between the two. So this witness, Welcher, Dr. Welcher, said one of the comments he had made in the course of the direct examination was about the injuries that John O'Keefe had. Remember, he had a blow to the head. What he died of, that blow to the head, as well as hypothermia, being outside in the cold all night. As far as the head injury, huge question about how he got it. Of course, what the defense says is he got it in a fight inside the home at 34 Fairview, and then they put him out in the yard. What the Commonwealth says is he got that when he was knocked multiple feet, unknown exactly how far or how exactly the accident happened, but he got it when he was knocked into the yard and landed on his head. That's when he fractured his skull. That's when he received those life-ending injuries. So in one of the things that Dr. Welcher had said is on direct examination, yeah, that's very common. Head injuries are the most common injury for pedestrians. Well, the defense would like to shape that. And they tried a couple of different ways. They asked him about, well, could that just be confirmation bias? In other words, you think that's the most common, therefore that must be what happened to John O'Keefe. And of course, we'll watch that. We'll watch an example of him asking about that in just a minute. But they also argued that it's just flat out wrong, that there is absolutely, it's not the case that there are more people who have head injuries in pedestrian collisions. He just has that wrong. Here's how that cross went.
So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony on direct?
I thought I did.
To me, that's not super effective because of the fact that he did put it on his slide. So the fact that he didn't mention it, if it was circled in red on his slide, I have a feeling the jury will kind of look past that. But the question of whether or not head injuries are really all that common is actually a pretty important question. And they're going to come back to it later in the cross-examination. It is, like I said, very difficult to pin down a witness like this, a skilled expert witness used to testifying. Here is how the rest of it went.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old, therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or bounce off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
Now, one of the things the witness does very effectively, and that is characteristic of a professional expert witness who is really good at what they do, is they never just answer the question. Occasionally, you'll be able to get a judge to say that's a yes or no, and they'll have to do it. But for the most part, that's not the way it works. The way they answer a question, and you will see the ARCA witnesses do the same thing, is they will answer with a long explanation. That makes it less likely that the jury understands the clear intent of the cross-examination. Both sides have witnesses who will do that. It's a sign that the witness is really good. Now, what he's saying, though, is suggesting that, yeah, it may be the case that now with safety features on vehicles, that it's less common to have a head injury and more common to have injuries below the waist to the legs. That's not what happened with John O'Keefe. And it's one of the points the defense has made. The defense says, why doesn't he have that? If he was hit by a car, shouldn't he have some broken bones? Shouldn't he have bruising? What about the legs? How does he get hit by a car and the legs are just fine? How does that work? So this is actually important cross-examination. Even though it's hard to pin down a witness like this, it really does matter. Now, the witness had a potential vulnerability that I do expect to hear more about tomorrow, especially if the defense experts have done what this expert witness is saying he did not do. Here's what it was.
You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I would use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No, I actually didn't set foot on the property.
You didn't set foot on the property?
No, I stayed in the street.
He seems
It's my understanding there were
surprised,
new
unless
owners.
he does.
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
There is...
Let's stop it right there for a minute. So one of the huge questions that the defense has raised is, what about the laceration above John O'Keefe's eye? It's a huge point for the defense theory, because even if somehow John O'Keefe's arm got injured in the taillight on the rear, how does his eye get injured also? It's a cut. It doesn't look like grass burn or anything like that. And how it is the forehead hit the grass anyway? Well, the defense believes they have an answer. The answer is that he was hit by somebody, maybe by somebody throwing the glass, but hit by somebody in the course of a fight inside the home. And that's where he was actually injured, not by Karen Reed's car out in the yard. So that laceration to the eye is a huge sticking point. Well, this witness believed he has an explanation for how John O'Keefe might have gotten it. There's a spoiler at the top of the back window in the Lexus SUV that Karen Reed was driving. And Brennan, the attorney for the Commonwealth, made a big point when the jury went out to look at the scene and to see the vehicle, saying, notice this spoiler at the top, notice this piece. Don't forget to look at that, because he knew that this was coming, that he was going to ask the witness to look at that. So the cross-examination, obviously the defense wants to poke some holes in that to create problems with that explanation about this bar at the top of the vehicle. So they pointed out that maybe the height of John O'Keefe wouldn't really measure up as the witness, Dr. Welcher, thought it would. Here's how they assume that, or here's how they asked it.
A berm raised above street level, correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb.
So the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin spoiler, because you don't have information as you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct? But you did.
Okay, so let me stop with that. In fact, I'll pull that one out. And I'm not going to stop. I mean, I have much more for the presentation tonight. What I mean is, let me stop at that particular video. Notice at the end how difficult it is to cross-examine a witness like that. For example, he says what he wants the witness to say is, look, there's at least a possibility that if if John O'Keefe was not standing directly upright when he was hit by the car, that it wouldn't even measure up to the eye. And the witness says, well, he could have been leaning over. He could have been this or that. If he was a little higher up, he might have been leaning over. Maybe his head was in a different position. And he even gets in this. He just throws it in there. It could be from contacting the ground. And Alessi is surprised, pardon me? He says, it could be from contacting the ground. It could be from other things. And a really skilled witness will do that, will bring in all those other factors and make it much more difficult to cross-examine. So what you saw was a very skilled witness today. But of course, Alessi is also an extremely skilled attorney, and you're going to see more and more as the afternoon wears on and he begins to be able to make a few more points. So as far as one thing I forgot to say, as usual, would you mind hitting the like button? That'll really help us bring more people into our live here, and I would really appreciate that. If you aren't a subscriber, please subscribe. We'd love to have you back for more videos. All right, so let's take a look then at what happened in the afternoon. Now, what Alessi wanted to do was to get the witness, Dr. Welcher, to say where on the car it would be possible for John O'Keefe to have broken his hand, because the witness is very hard to pin down. Of course, we know there was no finding that John O'Keefe broke any bones, much less the hand or arm that was hit by the taillight. And so Alessi wants to say, well, okay, if nothing broke, you have to admit that in certain places on this car, if he's being hit by a car going over 20 miles an hour backwards, surely he would break some bones. And here's how that cross-examination went. Let me make sure I have the right one. There we go.
Any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit, 300 to 400 pounds of force could break it. Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything you see there could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand?
So, I don't know how to show this because in the middle photograph, right where the 2 is on the license plate,
Yes.
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right, so now
Alessi's going to up the ante and going to say, okay, but you say there were even more pounds of force. So let's assume it's even more pounds of force. Where on the back of the car could you get a broken bone from that?
let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is a number I calculated for you. It's not, quote, my number.
I understand, but we did.
So-
I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So probably similarly, if you got your forearm down near that transition, like, I don't know if you can see the little dot. I'm talking about this area.
Yes. Yes.
Right here.
Yep.
So that transition between the two body panels.
Yes.
That could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well. It's a much more narrow loading condition.
How about the corner of the tail?
Corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Potentially. But you didn't do any of that force analysis for this case, did you?
For the hand, no.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
You are.
So as you can see, Dr. Welcher is not acknowledging anything. He's being very careful to say he doesn't know, or that he has lots of questions about whether there's anywhere that would actually cause a broken bone. I'm not sure whether this was super effective questioning anyway. I don't know how much the jury understood what Alessi was trying to accomplish. He obviously was trying to get the witness to say that there could have been a break some other way. The problem with that is the witness says that isn't how it happened. There was no break in this other way. So I think that makes it difficult for the cross-examination to be something that's understood by the jury. I think they're going to have a hard time understanding it. It kept going. We'll listen to a little bit more.
Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray, from the records I've seen, either his hand or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm.
Are you aware that the medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes.
And you're aware of it because you read the autopsy report, correct?
Correct.
Are you implying, and it's a question, that Dr. Shorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No, I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there'd be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated it and found a comminuted fracture. So we're talking about proof.
Sir, I didn't use proof in my question.
Ask me about the opinion of a medical examiner. I'm not a medical.
Time. Only one person at a time. Mr. Alessi, let him finish, and then you can ask the question.
Your Honor, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond.
So
you can see how frustrated Alessi is. And I have a lot of sympathy with that, because when you try to cross-examine an expert witness like this, it is very difficult. I mean, they are really skilled and they know their field, and it's a difficult process. It's not just that it's difficult to cross-examine them and get them to admit anything. That's enough of a problem. But you have to cross-examine them, get them to admit something, and it has to be clear to the jury what they just admitted. And all of that is a hard process. So I think in this, his pitch was, so this is all about you're critiquing another Commonwealth expert, Dr. Shorty Bello, and she is the one who didn't do this x-ray. You think that's her fault. I think that the witness in this particular case had a pretty good point. There wasn't an actual x-ray that would pin down whether or not there was something broken. That's a little bit of a gap. It's just something that both parties have to live with. There are gaps in the middle of this. But I understand the frustration that Alessi is feeling as this goes on. Now, they went into sort of an exhausting, very, very lengthy discussion, which I will not play, about the fact that the witness believes that the vehicle that Karen Reed was driving moved 30 feet forward and then 50 feet backwards from the original starting point, meaning a total of 80 feet backwards, which is a very long way to accelerate backwards. And that somewhere in the course of that is when John O'Keefe was hit, or maybe shortly after that. So, and that there wasn't even braking there at the end, meaning this was really a pretty long backing sequence. Now, that's always been kind of a strange point in the Commonwealth's case, because of the fact that backing that far is unusual. Backing while accelerating and being able to do it in a straight line, that's also kind of unusual. All of that has been sort of a difficult point for the Commonwealth. So Alessi asked some important questions around this when he was cross-examining Dr. Welcher.
the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
I mean, it doesn't necessarily work that way. I mean, you can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage. But it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is you can have an accelerator pedal depress greater than 30% and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. Do you understand what I mean by a correlation?
Let me, if I may, try and straighten this out. So, applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at.
So after a really lengthy, most of which I left out, they finally come to the point that I think is a really important point for the defense. And the witness actually agrees with him that, yes, what could be happening is that the wheels are slipping. It's a wet night. Snow is starting to fall, even though that's just barely beginning now. And there's nothing yet on the ground from what the witnesses have said. But maybe the wheels are spinning. Maybe they're trying to move backwards. Maybe Karen Reed is, or trying to move forwards, and the wheels are spinning. Maybe the reading that Dr. Welcher is getting is based on something that isn't really motion forward or motion backward. Maybe what he's seeing is that the wheels are slipping as she's trying to move the vehicle. I thought that was a really important point, because it is such a confusing situation that she would suddenly back for that lengthy period of time. But it also does leave open a possibility for the Commonwealth to argue that maybe she was moving backwards. She was trying to move backwards, and her wheels were spinning, and maybe she suddenly, in the course of that, hit John O'Keefe. I haven't heard them argue that. I wondered if maybe they're going to take what this argument has been and try to turn that. I want to say thank you to Jackie P. for gifting 5 Lawyer League memberships. Thank you, Jackie. We are having an absolutely great time as with our memberships. We're writing a true crime novel. You can hit the join button, or be sure to turn on your ability to receive a gifted membership. YouTube may select you in their random selection process. So thank you, Jackie. And Vicky also gifting 10 Lawyer League memberships. I appreciate that very much, Jackie. All right. Sorry, very much. Vicky, I already thanked Jackie. Thank you, Vicky. Annie Bev Squeaky Chair is talking about the Lexus having an auto leveling suspension, and that may throw the scans off. Let me say this. Alessi is only, according to what he told the judge, only halfway through his cross-examination of this witness, and he went all day long. There was a brief period in the morning from Brennan, and other than that, it was all cross-examination of this witness. So there may be hours and hours to come. We may learn a lot about what's going to happen, what some of the best points with this witness are. Right now, we've just gotten barely into it, and Alessi is starting to ask some of the most important questions. Thank you, Christy NC. I appreciate your super chat very much. All right. One of the important points I felt like that Alessi made was that in order for John O'Keefe's arm to have gotten the injuries that it did from the taillight, basically going into the taillight, that the arm would have had to travel with the car a little bit. Let's listen to what he says, and then I want to talk about the paint test and the arm.
You do not agree that the injuries to Mr. O'Keefe's forearm, under your theory, would be oriented in a vertical. You disagree with that. It's just want to get that on the record.
I disagree with that.
Okay. Now, also, do you understand that under your theory of injury here, that there would be injuries caused in 2 different directions by the same movement of the car? Agree or disagree?
I'm going to say I disagree. You need to give me a little more. You're going to have, again, this is a glancing or a clipping type impact. And so it's going to be it's going to sweep across the arm, which is what causes the horizontal lacerations.
We're talking about a flat surface, right, sir?
Approximately, yes.
And therefore, you would have to maintain contact with the arm as the car moves. Am I correct about that?
Maintain contact with the arm? I'm unclear what you mean.
What I'm trying to do, sir, is to get under your theory, right? Given the contact that you've described, what would you expect to be the orientation of the wounds to the upper part of the arm and to the lower part of the arm?
Just like it's shown in this photograph.
Okay. Isn't it the case with your theory that the tail light would have to break, and after the break, the arm would have to maintain contact with the arm as the car moves?
So that is what happens in pedestrian contacts. There is a contact duration. So at a point in time, it'll stop contact. But the 6,000-pound vehicle is going to want to continue moving on. It's going to push. It's going to initially contact the arm and then push the arm away as it rotates the body. So yes, it's going to maintain contact until the clipping is over and the vehicle continues on.
So let's talk a little bit about the arm. Yesterday, we watched the test that this witness did, and they tried to call it something other than a test, but this witness was like, no, that was a test. So I think he wanted to call it an experiment or something more derogatory, something that made it seem a little demonstration or something. And the witness said, no, I want to call it a test. So they did. But you may remember that what the witness did was put paint on the tail light itself of a Lexus, exactly like Karen Reed's. And then he rolled past it with his arm as if he was being hit by the car. And he also had the vehicle come back at him at just 2 miles per hour and did a roll right through like that. In each case, you saw that his arm got blue right through here. And they put John O'Keefe's arm next to it with his injuries right here. I thought it was pretty effective. So Alessi is trying to break into that and convince the jury that it's not very likely to happen. So essentially what the Commonwealth is suggesting, what Dr. Welcher is suggesting, is that the vehicle hit him and John O'Keefe's elbow literally went into the taillight. Basically, it broke as the taillight broke on it. And that's how all those scratches occurred, as it was pulled off. And then he was thrown away. So Alessi is trying to say, well, what that means is that John O'Keefe has to be with the vehicle for a period of time. And the witness is saying, yeah, that's what happens with car accidents. That, though, is going to offer an opening for the defense experts, because the defense experts are going to say, okay, let's say he's right. And this is carried, that John O'Keefe's body goes with the car for a little bit. There are going to be bruises. There are going to be broken bones in other parts of the body. So we're going to hear more about that theory when we hear from the expert witnesses for the defense.
Direct, you stated that in order for the injuries on Mr. O'Keefe's forearm to have been caused by an impact with the taillight, his arm would have needed to be held outstretched as you did in your demonstration, correct?
You would need some degree of outstretch, yes.
Yes. So isn't that an example of confirmation bias?
No, that's matching the contact pattern to the injuries.
But don't you have to select, among other choices, this outstretching of the arm? You had to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car, and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion to hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never
Yes,
asked.
you have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
All right. I am not going to be asking any questions that involve the taillight in any fashion.
I thought that was hilarious at the end there. I'm not asking about tailpipe or taillight. Don't ask me. Don't expect me to ask anything about that. And of course, Karen Reed does not believe that John O'Keefe was hit by the taillight, that her taillight was cracked in any way related to her having hit John O'Keefe. So, but notice what was said there as he's being asked about, do you have confirmation bias? I thought that was kind of a stretch by Alessi, So isn't this confirmation bias? I mean, a witness like this is never going to say, yes, that's what it is. It's confirmation bias. Now, Alessi's point is to signal to the jury that maybe that's what it is, but this witness is never going to give him the satisfaction of just answering that. Sandra, thank you so much for the super sticker. I appreciate that very much. I see a comment from Barbara asking or talking about if the arm was bent, there would be vertical lines on the upper arm. The lower arm would have to be horizontal. No way they all go the same way. Now, there was cross-examination on that very point today, but the witness kept saying, show me picture, I've forgotten the slide number, and I will show you how it looked on my arm. And then you can see that that is what happens. Now, of course, Alessi very wisely said, well, no, we're looking at this other slide right now. That, of course, will be something Brennan will come back to. I don't know what those slides look like. I don't know what those arm things look like, but I'm really curious to see them, since what you say, Barbara, makes a lot of sense. And the witness is saying that isn't how it looks. So I'm really curious to see what will actually happen when we see what those patterns look like on the redirect examination by Brennan. Helen, thank you so much. She's saying, let's get to 200,000. We are so close. We would love to have you join us. Please hit that subscribe button if you're not a subscriber. We would love to have you back for more, and you can help us get to 200,000 subscribers. All right, so the last part I want to talk about is an argument that happened outside the presence of the jury late in the day. And there was, the point, I believe, of it was related to a bunch of private conferences that happened at the sidebar that we don't know about, but it seemed to be about the defense attempt to get two things into evidence so that they can cross-examine this witness on them. Number one, and most important to them probably, well, both are important, is Trooper Paul. They would really like to be able to cross-examine this witness with Trooper Paul's report. One of the ways they tried to do it was by showing that pieces of Trooper Paul's report had filtered into the report this expert made, and therefore he relied on Trooper Paul. They would have really liked to have done that, unless he asked questions about a drone image shown in the report of this witness, Dr. Welcher, that was also in another slightly altered form in Trooper Paul's report. But on cross-examination, that drone image, well, that was cross-examination, but on redirect, or the direct examination in this case, because this was just outside the presence of the jury, but the Commonwealth got up and made the point, and I don't know if it was really in evidence. It was a long question designed to state something. He said, did you know that this drone image was actually not something Trooper Paul came up with in the first place, but instead he got it from the CERT team. So it's just evidence. It's not anything related to Trooper Paul. And the witness said, well, I don't know anything about that, but I think the judge will probably say that did not open the door. And that doesn't mean that there will be, I'll go ahead and remove that. That doesn't mean anything will be, has allowed Trooper Paul's report to come in yet. I'm sure they will fight it all day long tomorrow. The other thing they really wanted to get into evidence is Dr. Scorti-Bello, the medical examiner's ultimate conclusion about the manner of death. Here is how that went.
The slide that you had has the final diagnoses of Dr. Scorti-Bello, and you put that in your slide presentation because you considered that as part of your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death. Right. The things I highlighted are the things I thought were important. So the highlighting on slide 130, so the final diagnosis, again, does not include cause of death. It does not include manner of death. There's that horizontal line demarcating those. The important things that I was looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the ones that you highlighted, you considered are from the autopsy report. That's why you're highlighting them, right, sir? You considered that.
Correct.
Thank you.
So at that point, it sounded like Alessi really believed he had scored a point that would let him be able to get that opinion from Dr. Scorti-Bello in. I didn't think it had gone as far as to allow that in yet, but we'll see tomorrow. The judge will be ruling, and we will find out if they get that in evidence. So I want to talk a little bit about the day, but I also want to get started on some questions. If you have a question, if you could put question marks at the beginning of your question, it'll make it a lot easier for me to spot in the middle of the chat as it rolls by. So, and I want to welcome Reese, who is a brand new member. Thank you so much. All right, and we'll and don't forget to turn on your ability to receive gifted memberships if you haven't done that yet, or to hit the join button. If you're on your iPhone and you can't find the join button right next to the Lawyer Lee title under this video, then you will have to go in through your browser, not just through the YouTube app, or you can always use your computer and then it'll show up. Some kind of turf battle between YouTube and Apple that is creating that problem. Okay. So let me take a look over here and see if there are any questions over here. I think overall, my assessment of the witness is he's very skilled. He's very good at what he does. He's difficult to cross-examine. I think Alessi is starting to make some headway. It's not going to be the sort of blistering, all-out cross-examination we have seen of some witnesses, because he's just too skilled at being able to parry that, to keep all of those things from hitting. But there are some important points that Alessi is making and will make even more tomorrow. So we will find out a lot more. This is an all-important witness. And I'm not the only one saying that. Alessi said that. In the middle of in the argument later today, he said, you know, I need all the time because this witness is all important. This witness is critical. And that's what both the Commonwealth and the defense think. This witness is what it's all going to come down to, at least in terms of the Commonwealth's theory of how the case happened. The defense believes they have poked holes a lot of different ways, but here's the witness who says, yes, it could have happened this exact way. So they really want to break into his testimony and convince the jury that he's either not believable or that what he's concluded doesn't make logical, scientific sense. They, of course, also have expert witnesses who will say that. Okay, so let me look for those question marks at the beginning. I don't know if I'm starting exactly right, but here's Carmina. When asking, this is a good question. When a lawyer says strike that, does their previous comment still end up on the transcript? So, and if the judge says to strike an answer, typically the transcript should include everything because those issues, those rulings may make it up on appeal. And somebody may want to be able to say, you know, Judge, she struck this answer and it was really important. The jury should have been allowed to consider it, or she struck this question. And so typically that would be at least recorded so it would be available for appeal. It's supposed to be struck from the consideration of the jury. They're not supposed to take that into account or consider it in any way. Great question. Okay, MEP asking, could the woman Chloe Bitt testify for the defense and submit bite photos? There would have to be, there's been no evidence presented yet that Chloe had anything to do with this. We would have to see what comes in. Probably not. There is, but I don't know. It would depend on whether they could prove that was an other similar incident and there were enough correlations between the exact bite marks, what happened to John O'Keefe, and what happened to the other person. I think it's really, really unlikely that the judge would ever let that in. I just can't imagine her deciding that would come in. All right, looking for question marks at the beginning. Here's Kurt. What did you think when he opined the car could have gone to space? It came up showing how little he knows. So I think that just as the cross-examination is difficult for Alessi, it's also frustrating for the witness. And that's why you ended up, that little section I put in where they're talking over each other, you can tell the witness is frustrated too. Now he's very skilled, but that doesn't mean he's not going to be frustrated. I mean, Alessi's a really intelligent, skilled cross-examiner, so he's got to deal with that as well. So I think some of the comments he made could come off negatively to the jury, one being what you mentioned. Bidley Widley, do you think the judge should have admonished the witness more because he avoided answering the questions? Most judges will give expert witnesses a lot of room just like this. I suspect she will pretty much give the ARCA witnesses the same amount of room. We'll see. Maybe I'll have that wrong, but I think that's what we will see, is that she'll let them kind of talk around the question, add extra. If Alessi were to ask her, Judge, I'm asking for a yes or no, she would have to make a ruling on it, but he hasn't really pushed for that yet. Llama Pajama asked, what did you think about him using his laptop even after the judge told him not to? I'm about to give a very unpopular opinion here, okay? I think the whole rule that experts shouldn't look at their reports is utter nonsense, utter nonsense. We all rely on what we write down. It doesn't mean that we don't mean it. It just means our memories, there was a reason why you wrote that down, and that's so that you could know it plainly, crisply. So I think that they should be allowed to look at it anyway. So super unpopular answer, but just my opinion, I just think that's how it should happen. As far as him using his laptop, I think he was just, he wanted to get into those documents and prove things, and he's really not allowed to do that. She's kept a firm rein on all the witnesses on doing that. I think Alessi made pretty good use of that by saying, Judge, I want a ruling here, because he keeps doing that. I didn't think it was too bad. He stopped at that point, but Alessi got a little margin out of that. He got a little mileage with the jury on that, I would say. Why was the voir dire important at the end of the day? Pug and Spice asked. It's because they would really like to get in some more information that they haven't gotten in, and they were hoping that this witness has opened the door, that they're going to be able to use this witness to get in some of this information. That's what the defense wants. So far, it doesn't look too likely that the judge is going to rule on that in favor of the defense. Brad Tipton, what evidence would you be looking for without witnesses or direct evidence? Is the taillight enough direct evidence? Is witnesses to admit this enough? So it depends on the case, Brad. In this particular case, what the Commonwealth is going with is the taillight piece. And in fact, there was a really good segment. I saw somebody asking for it earlier, and I'm not playing it tonight, but it was a really good segment. You were right, where he just suddenly listed, he was asked, so all you have is taillight pieces. He's like, no, it's not all I have. I have taillight pieces, and I have the fact that he hit his head, and I have the fact that her car was moving backwards, and I have the fact of the timing. And he listed thing after thing, physical and pieces of evidence, and also electronic pieces of evidence. So what amounts to enough? That's honestly just a jury's call. We're going to have to wait and see what they think. Of course, we'll be making up our own minds as the case moves along. Okay, Bonbon RPH. Not sure if you mentioned the cost of this witness, but do you think the Massachusetts jurors will be horrified that the state is paying $325,000 or possibly more? So that is a great question, Bonbon. That is one of the big issues with expert witnesses, is how much they cost. Now, I need to mention a couple of things. The witness said that this was the cost, something like that, was the cost of the Lexus that they bought as an exemplar. But they plan to sell the Lexus, and he said we may even make more on it. She struck that as speculation. But he said we're going to sell it, and all that it costs the Commonwealth is the difference between what we had to pay to buy it and what we sell it for. So it may be that we're able to sell it for even more. It will cost the Commonwealth nothing. But as far as the general topic of expert witnesses costing a lot of money, while shocking, wait until you hear what the other expert witnesses have been paid too, because they make a lot. It is highly common for an expert witness to make $1,000, $2,000 an hour. And for them to charge, for example, travel time to get to the trial, not to mention each hour of the trial. I once had in a case, and this is 20 years ago, at least, maybe longer, I'm not sure, long time ago. I'm dating myself. But we had a witness, an expert witness for the other side, and his company had been paid over $1 million. And this is 20 years ago. This was paid across more than one case. But these expert witnesses cost a fortune. So I think they might be horrified, but they're going to be horrified again and again as they hear that all of the witnesses cost a whole lot of money. That's very typical for expert witnesses. And we do know that ARCA was paid. I don't remember how much they were paid. It was obviously nowhere near $325,000. But I think a lot of that payment, and I think all of that payment may have been for the car, and that the expert witnesses had only billed $40,000 so far as their time, which I hesitate to say this, but frankly is quite reasonable for a case like this. I'm very surprised by it. All right, Evergreen 101. How did the glass in the hand get in the yard after breaking the taillight? So I don't know if they're really saying that glass broke the taillight or the elbow broke the taillight. I don't know if they have a theory. I would say this witness would say he doesn't have a theory. He would say this witness is not really clear on how it happened, simply because there is not enough evidence. No one can possibly know exactly what happened. Marlon, one of our two mods, saying that Jerry says hi. Marlon has a new puppy, totally adorable little puppy. Sending our love out to Marlon's new little puppy, Jerry. And so I want to say too, while I'm at it, I so appreciate Marlon and Mama Pinks, who help us every night going live and who are really committed to helping us try to keep the chat a smooth and happy place. It's not easy in a case like this. This is a case where people have strong opinions and they fully form them. And unlike just about any other case I think that I've covered, people have already made up their minds. Now, that's maybe not surprising because people often listen to the entire first trial. So it isn't like they're coming in with no information. They're coming in with information. But it does mean that it's difficult. So I really appreciate what Marlon and Mama Pinks have done to try to make this work for everybody. Miss Lizard, is it normal for a witness to be allowed a tablet to take notes, etc., like this witness did? Well, no, in fact, it's not. But as my opinion was earlier, I think it ought to be. I think that's a ridiculous rule. Just my opinion. And I get it. What they don't want is a script to be written down and then somebody just reads the script. That could obviously be problematic. But experts have already written their script. They get to write their own report. So in my opinion, it's kind of a waste of time to do this. Oh, I don't remember. Let me look at my report thing. I think that's unnecessary. Tina C, has anyone testified to the reliability of the text stream data, especially in the way they're trying to use it without a corroborating witness? So they've used the text stream data and they've said this is data that would typically be relied on. They talked about how it was downloaded. There have obviously been questions from the defense, not just about the reliability, but how it was actually calculated and how it was used. So that's more something for cross-examination. All right. Well, I think we've thanked everybody. I will look forward to seeing you all at 7 p.m. tomorrow night. There's only a half day of trial tomorrow, so it'll be a little bit shorter day, and I will look forward to seeing you tomorrow night. Don't forget to like and subscribe.